Hello, everyone. I'm back. For those of you who don't know me, my name is Andre McKinney Dorval. I am a licensed immigration attorney. I am located in the state of Florida. Guys, I have been busy these past 2 weeks. I have been in trials and in hearings. There's a lot happening in the immigration streets. And let me just say, things seemingly will be changing what feels like on a daily basis. Let me kick off this video by sharing good news that we've all should have already heard, and that is the lawsuit concerning the CHNV parole revocation. This was a lawsuit that was filed back in late February ahead of the formal announcement in the state of Massachusetts. And in the last video that I shared with you, I shared that the judge would be considering whether or not to issue a preliminary injunction, basically putting a stop or a block on the termination going into effect as the case continued to be litigated. Well, Judge Indira Talwani issued a preliminary injunction this past Monday, basically halting the government's parole revocation. Now, interesting enough, what the judge pointed out and argued is that the parole revocation was not done on a case-by-case basis. Now, the federal judge, in blocking or halting the termination of CHNV parole, also stayed all individual notices that were sent to non-citizens that their CHNV parole was revoked pending further court order. Now, the Trump administration is appealing this decision. So for now, CHNV parole remains in place as this case works its way up through the court system. Now, let's move on to update number 2. Guys, the IRS has officially entered into a memorandum of understanding with DHS to share taxpayer information. Now, the memorandum is approximately 15 pages. We won't go into detail in this video, but much of that memorandum is redacted, so it's hard to say, based on the reading of the redacted document, how much or what exactly is going to be shared. Suffice it to say, from what the details indicate, ICE will be the one to initiate requests with regards to information on taxpayers as it pertains to if someone has overstayed, and more importantly, individuals who, let's say after an order of removal, who haven't departed within a 90-day period. I will follow up with more details and share with you the contents of that particular memorandum. Thirdly, last Friday, April 11th, it is in effect, guys. Registration is officially in effect. Now, that policy decision or enforcement decision by the government was also challenged. That challenge was not successful. The courts have ruled that the Trump administration may proceed with registration requirements. It is an online form. We did do a video briefly discussing that. The form is the G325R, I believe it is. We'll do a separate video. Now, guys, you'll recall, or if you don't, please check out the prior video. That particular application does ask quite a bit of information. I will more than likely share an updated video with regards to what a blank application looks like to showcase some of the questions. But as we previously discussed, most individuals have evidence of registration, such as lawful permanent residents, individuals with employment authorization documents, if you were issued a notice to appear, if you have an order of supervision with ICE where you're checking in, if you have an I-94. We also published a video that went into deeper detail with regards to, by and large, many people have evidence of proof of registration. Now, the last and important as well updated information I want to share with you guys, because this is already affecting many, many people, and many more individuals will be affected. And that is, guys, this past Friday, April 11th, once more, the Trump administration did issue a policy memo. This policy memo speaks to guidance given and basically, the green light to immigration judges to pre-termit insufficient asylum applications. What does that mean? When a application is deemed to be permitted, that basically means that the asylum judge, the immigration judge, can decide the asylum case um, without having a hearing and taking an oral testimony if the asylum application is legally insufficient or if there are no factual grounds in dispute. This is going to be very, very impactful to many people. For example, many individuals, because they're faced with the 1-year bar or 1-year time frame in which for you to apply for your asylum application, many individuals often apply for asylum without the assistance of a licensed immigration attorney to be able to assist them. And so in cases like that, or even otherwise, because you could have an attorney and your filing could be pretermitted as well. In instances like that, the judge, just with the filing, no testimony at an individual hearing, can decide the case, and deciding the case could mean that the case could be denied. And in cases where it's legally insufficient, that is what's happening currently right now. Now, I want to read portions of what the government's memo indicates. And it says in this memo that was issued on last Friday, and I'm using the term, I'm reading directly from the document, if an alien fails to set forth prima facie eligibility for relief, such application generally can be pre-termitted. Again, pre-termitted is in the context of immigration, is a legal term that simply means denied without even giving the asylum seeker a chance to testify or a chance to cure, arguably. Now, what should you be aware of, and what should you consider? Number one, if you are someone who is eligible to file for an asylum application, work with an attorney. It will be very important and strongly encouraged and urged that you want to have an opportunity to be heard on your applications. Guys, you'll remember I did a prior video and I said at that time, what was happening is that the government attorney was terminating or asking for the asylum case to be denied. And in that video, I shared with you some considerations in terms of things that you could consider working with your attorney to do in order to be able to afford yourself the opportunity to be heard on your asylum application. In this instance, this memo that has gone out this past Friday, having an application pre-termitted, basically decided and denied without an opportunity for you to put on evidence, that in part removes your ability to have an opportunity to be heard. What do I mean by that? An opportunity that you are in immigration court, your attorney is asking you questions and eliciting the answers that supports your claim for your immigration application. Now, I will say that it is almost virtually, in my professional opinion, almost virtually impossible to account in an application the full extent of what someone could testify in court. Because as a trial attorney myself, when your attorney asks you a question, you provide an answer. That affords the ability for follow-up. In an application, there's no question and answer in the same manner as it is when you are in court. And due process encompasses all of that. So it is going to be very important, number one, that your application has to be legally sufficient. And in the memo, in fact, they describe in other application instances, let's say, for example, if this were an I-130 or an I-485, where let's say if something wasn't sufficiently provided and USCIS would probably issue you a notice of intent to deny or a request for more evidence, things of that nature, or sometimes just deny the application because it's illegally sufficient. The easiest example is if you don't have the correct filing fee, they're not looking at that application. And so they seem to be applying that same type of rationale with or within the context of asylum. And that is going to be very important. Another thing to remember that we talked about, there is a backlog in asylum applications, approximately over 3 million the within the 50 states. And that's a lot. Guys, I cannot underscore that every tool that can be used will be used to amass the greatest amount of mass deportation of individuals. So for those of you who maybe are working on an asylum application or have an asylum application within the system, or are considering filing asylum, be aware that the memo has gone out, giving guidance to the adjudicator, which is the immigration judge, that they may pretermit, just a fancy legal word, that they can, adjudicate and deny insufficient applications. Guys, I do thank you so much. I thank you for all of your support. This was a very quick update. I will be sharing individual videos on the subject topics that require a little bit more information and guidance and to share with you in terms of what is happening in the immigration space. I do want to thank all of you for your support, my new subscribers. Thank you so much for watching. Please be sure to like and share this video, and I will certainly see you in the next video. Bye-bye.